Good afternoon. My name is Milam Newby, and I'm thrilled to welcome you to the next installment of VNE's Technology Series webinar. Today's webinar will focus on antitrust issues in the technology industry. Before I introduce our speaker, a few housekeeping items. We are recording today's webinar, and a copy of the webinar and corresponding slides will be available in the coming days. For those of you looking for CLE credit, there will be two polling questions that appear throughout the webinar. Please reply to both of the polls so that we may verify your participation. Finally, we encourage you to ask questions. I'm going to monitor the chat. We'll do our best to address any questions as they come up. If we have time at the end, we will address any questions that we don't get to during the presentation itself. It's my pleasure to introduce our speaker, Hill Welford. Hill is a partner in VNE's Washington, D.C. office, where he serves as co-chair of our antitrust group. Prior to joining VNE and entering into private practice, Hill served in several positions in the DOJ Antitrust Division, including Chief of Staff, Trial Attorney, Investigator, Policy Counsel. He's a longtime leader of the ABA's Antitrust Division and is a globally recognized expert on antitrust matters. It's my pleasure to turn the presentation over to Hill. Thank you.
Great, thanks very much. So as Milam mentioned, I've been doing this for a while. It's unbelievable. I'm in my 28th year of doing antitrust. I do a ton of energy work, as you might imagine, being at Vinson and Elkins. I also do a ton of tech law. When I was at DOJ, I was originally hired into DOJ as special counsel for intellectual property. Back in the day, I was both a patent litigator and an antitrust litigator, so I ended up specializing more into antitrust, but I still have that love for technology. And happily for me, being at this firm in particular, energy and tech are kind of starting to become one and the same. There are things like, electrical grid management, renewable energy of every possible stripe, energy transition, battery technology, even things like traditional carbon energy. You've got, pressure pumping is controlled by computers these days. Horizontal drilling strikes me as a lot easier to put a person on the moon than to drill 40,000 feet laterally, and yet that is done, in virtually every gas well that exists today. So technology is all around us, and as a result, it is no longer the case that you can say, what's happened in Microsoft, that doesn't really affect me. These antitrust issues in technology they're all around us. So it's really useful to know what's going on. Right now, the people who are in the crosshairs are the Amazons, the Microsofts, the Apples, the Googles. But those same kind of issues are coming to every portion of the technology industry. So we should go ahead and get you familiarized with them. So what we're going to do today, in order to start break down a lot of these cases that are in the news, I think we need to start a little simpler. So we're going to start by talking about the economics and some themes, and then we'll go into the specific cases. Each one of these is going to be illustrated by a case. Some of these themes are platform sponsorship and seamless integration. That's what the companies and the defendants usually say is, don't attack me for doing something bad antitrust-wise. I am the sponsor of a technology platform. I am just making sure that my technology works and it's seamlessly integrated. Whereas on the other side, the DOJ, the FTC, private antitrust plaintiffs, they're pushing back and saying, no, this is a case that is about access. It's about your self-preferencing, meaning you using your own technology to benefit your own company in ways that the consumer wouldn't, that isn't transparent, that the consumer doesn't understand, that is unfair in some way, and that you are preventing customization and competition by having too tight a grip on your technology. Your technology is, you're keeping it too much to yourself. You've got to open it. You've got to share it in some fashion. You've got to allow us to use it, either access to it or actually take a copy of it and compete with you. So those are some of the questions we're going to be exploring here. And easier to understand them if we start with sort of the basics and the economics, and then we get into the individual cases. So that's what I'm going to do. So backing up all the way to the beginning, we're going to do some economics here. So what is a platform? All of these things are the cases these days. They have to do with technology platforms. And just to make sure we're all sort of operating from the same thing, the definition that I'm using is an underlying technology upon which other technologies sit and work. But there's an underlying separate sort of network that things are sitting upon and working within. Typically, these are other applications on top of software. So for example, Microsoft's operating system, the basic Windows operating system, that powers a personal computer, but on top of that, you have browsers and printers and Word software and what you're looking at right now. So that is an example of a platform. If the more you think about it, the more that platforms are all around us, and you end up with this sponsor and then apps or other things on top of it. And so this is a little illustration. You've got users, you've got device makers, you've got app publishers. This certainly, here it would be the platform sponsor is Microsoft, users is you and me, device makers is Dell, HP, Lenovo, and the rest of it. And then app publishers or software publishers, that's going to be everybody else who's not Microsoft, who's also working within that. The key feature economically, and we need to talk about economics because antitrust is supposed to follow the economics. It's supposed to respect efficiencies that are created by good economics. The key feature here is that these are what called two-sided markets, and the better term is really multi-sided markets. There's the total market, which I'll mention in a second, and then there's these individual little markets, or at least individual little aspects. The users, the device makers competing with the other device makers, the app publishers competing with other app publishers, and all of these in some fashion are charged something. Everybody is on that platform and is being charged something. And the question is, how do you balance that? Are the users and device makers and the app publishers, they have different, they are paying different things to be on there, and they have different interests, and sometimes those interests conflict, and somebody's got to resolve that. And that economically is actually a pretty fascinating question, because how do you figure out whether the device maker is paying too much or being restricted too much if the argument is, well, we are making sure that the users aren't paying too much. So we're charging the device maker in order for the user to have something discounted or free, and we're protecting the user, and the device maker has higher cost because of that. Something like that is relatively difficult to model economically, and that's what people struggle with in these cases. The role of the sponsor is to make that decision. The sponsor, here it's Microsoft, they've got to decide, all right, how difficult am I going to make it to put an app on my system, and how much am I going to make sure that app is secure to protect my users, and how much am I going to charge the users, or am I going to make Windows free to the users, and then I'm going to charge a whole lot to the app publishers. Microsoft has made a decision that they're going to charge the users a little bit, and then they charge the app publishers a little bit, and then they work with the device makers. Other platform sponsors make a different decision, and it's really hard to second guess that, because if you say, well, Microsoft, you got to reduce your prices to users, most likely they're going to have to raise their price to somebody else. So that's the kind of thing that when you're in, I can say this from having been at the DOJ Antitrust Division, that's a difficult thing to try to parse as an enforcer. So this is what all platform manufacturers and platform sponsors say they are doing. They're trying to create a virtuous cycle. You've probably seen something like this before. We want to bring more users in, make them super comfortable, because that's going to make more devices, more accessories, more apps and content. And guess what? Then more users come there. On around and around, and starts. This is another way to say this is network effects. The more people, devices, etc., are on there, the more they are interacting with each other, the more valuable it becomes. And the idea is it takes a life of its own. And you do see this with platforms. We'll mention in a second that it also can go in reverse. But this is the idea. This is what platform people always say they're doing. They're protecting the virtuous cycle. So what is platform competition? Now we're going to get a little closer to antitrust. When we say that platforms are competing, what do we mean? Well, it's really important to focus on what kind of competition is happening, because there's several different kinds. The competition between platforms, that tends to be the one that the platform sponsors are most worried about. So this is Microsoft's server, that's the NT software that runs servers, versus Unix. That used to be big. Microsoft versus Apple, that's still a huge battle right now. Microsoft is constantly, they have a more open system. Apple has an extremely closed system. Which one's better? Microsoft gets criticized every time it goes in the direction of Apple a little bit and makes things a little bit more restricted. Apple gets criticized for not being as open as Microsoft. Apple iOS and Android OS is an even more, it's even stronger example of that. Android, the thing that powers your the Android smartphones, that's extremely open. Apple iOS that powers the iPhone, that's extremely closed. And you see that there are antitrust lawsuits against both of them saying that they aren't enough like the other, which is kind of ironic. The other thing that happens is competition within platforms, and this gets complicated because it's pretty easy to understand if you've got two app makers, for example, two third-party app makers, okay, they're competing to be in the Apple App Store. But at the same time that Apple is a platform sponsor, it may also be competing with some of those apps that are in its own app store. And then you get these complicated questions about self-preferencing. So Apple, when can Apple say my app is better, even though it is running the platform, and therefore it has, at least in some people's view, a duty of neutrality as a platform sponsor. There is no duty of neutrality, by the way. There is no legal duty of neutrality, but there is a sort of an implied statement by these platform sponsors that they're going to be somewhat neutral. And there is a concern about monopoly leveraging. Again, it's not a duty of neutrality, it's a duty not to violate the antitrust laws, but the argument is, I'll go into this in more detail in a minute. The argument is that platform sponsors are leveraging their platform status to gain a monopoly in some other market other than the platform market, such as the app market. Examples are of competition within platforms. Retailers are bidding against each other to buy Facebook ads, device manufacturers competing to sell Android phones. Those are pretty clear. So key threats, and before we get into the cases, this will help you understand exactly what the defenses of these companies are. Key threats to the health of platforms, fragmentation is a huge one. Fragmentation is sort of an umbrella term for saying the parts don't work with the other parts. Your Android phone suddenly doesn't work with the Android apps because the Android version that has been installed by a Android OEM, by Samsung, by LG, whoever it is, they didn't add some part of the Android OS, which is open source. So they cut some piece out of it, and all of a sudden, an app manufacturer doesn't realize that's going to happen, and the app doesn't work. And then does the user blame the app? Does the user blame the Samsung for making the phone, or does the user blame Google? So nobody wants to be blamed. everybody wants to have enough compatibility, but everybody also wants to customize, and those are in some tension. There are also fraud and safety concerns. This is particularly big. We'll mention this in a minute about app stores. Consumers will leave if they feel like they're being defrauded, or if they have too much porn, or if their kids' information is being shared, etc. And then lastly, the interference with the sponsorship. If you take away some of the tools that the sponsors have to prevent fragmentation, to make sure that fraud and safety concerns are not too significant, or you just take away the sponsor's ability to fund their platform, so you take away some of their ability to charge what they want to charge, all of a sudden you can run into problems with the platform not being maintained as well as it should be. These are some of the things you have to worry about if you're bringing an antitrust case in this area, and these are some of the defenses that you will see people raising. So what does fragmentation look like? Fragmentation can be pretty significant. Your CLE poll is up there. And here is an example visually of what this looked like. In 2015, this is what all the different slightly different implementations of Android looked like on mobile phones. And this is what Google was dealing with in 2015 when it was coming up with a more robust version of its anti-fragmentation agreement and anti-fragmentation commitment to try to make sure that all of these devices ran the same thing so that app developers could rely on their apps to work on virtually any kind of a phone. This is, if you can imagine a situation, if each one of these truly functioned in a different way, from an app developer's standpoint, it would be catastrophically expensive to try to buy every one of these phones, test your apps, make sure that each new OS version, et cetera, that comes out on these phones is compatible with your app, et cetera. Pretty soon you're going to say, to hell with it, I'm going to only work with the Samsung Galaxy and maybe with the iPhone. And that is what, for example, Google is very worried about when it was looking at the fragmentation problems of Android. And interestingly enough, fragmentation it's not just people creating new and different versions. There also is a problem with fragmentation about aged versions. So for example, if you're Microsoft, you want to make sure that people are upgrading to Windows 11, they're not still running Windows XP or Windows Vista. So that's one of the things that platform sponsors have to worry about. They have to push upgrades and entice people to install those upgrades, or they have fragmented even against themselves. Even if there isn't a third party messing around with the software, there is a fragmentation problem just with older versions. Okay, so now we're going to get into the actual cases. The cases against Google's Android, there have been two Android cases, one by the EC, which was decided, the European Commission in Europe, that's their version of the DOJ antitrust division. They decided it in 2018, and then it went up to the European Court of Justice. Finally had some decisions there, still some appeals going, but that's winding down. And then DOJ filed a lawsuit in 2020 that has a lot of similarities to that. That lawsuit is ongoing. Here, this is a situation where fundamentally the question is Google misusing its anti-fragmentation policies to leverage its monopoly and make its search software more dominant than it otherwise should be? What Google did here, it created the Android OS in 2008 to compete with what was then the very nascent Apple iPhone. And unlike the iPhone, which is a closed source system, you cannot put the Apple iOS on a non-Apple device. You cannot edit the software on an Apple iOS device. Unlike that, Android OS is open source and free to download. You can go download the entire version, in fact, all old versions today by just going to the android.com website, downloading a copy. People find this kind of amazing, but it's really true. You can go down there and download a clean version of Android OS right now, the exact same thing that Samsung, for example, would download to make a new phone. But the problem with that is if you can edit an open source software, you can also mess it up and cause it not to work. So to reduce that, Google made preloading its proprietary software, which is like its search bar, the Play App Store, and several other pieces of software like that. Google Chrome is one of them. YouTube is one of them. The mix has changed over time, but those are some of the core items. It made downloading those proprietary pieces conditional on OEMs agreeing to accept an anti-fragmentation commitment. That used to be called the anti-fragmentation agreement. Now it's the Android compatibility commitment. But it basically says, I won't fragment. I will make sure that there are certain compatibility standards that I will meet. So this is what DOJ says is going on, and it's more accurate than not. There's a whole bunch of anti-fragmentation pieces to this puzzle. This graphic explains what they are. So DOJ, EC and DOJ claim that, yeah, it's a good idea to stop fragmentation, but you're stopping it too much. And what do they mean by too much? Well, what they mean, or what they say they mean, is that they claim that Google is excessively preventing anti-fragmentation, and if they permitted a little bit more, they don't call it fragmentation, they call it forking or customizing, but if they permitted that Android to be built much more significantly differently, then 1,000 flowers would bloom, and some of those new types of Android would become new operating systems that would actually end up competing with the so-called Google Android, and eventually would allow those companies or other app developers who worked with those companies to compete with the core things that Google makes money on, such as Google search. Google really objects to this. It says there is no Google Android. There is just Android, and there's Android that works well enough for everybody else's apps so that the apps don't break, and then there's Android that doesn't work really well. And what you are saying is we should have more Android that doesn't work really well, and we, Google, don't think that there is any market demand for that. If there was market demand for that, we'd be happy to meet it. But what we instead, says Google, what we hear is that instead app developers are screaming every time they find that there are incompatible devices out there, because users don't usually blame the device manufacturer when the app doesn't work. They blame the app, and then they never try to use the app again. And that drives app developers bananas. And eventually app developers, especially the ones that make a lot of money, spend more time developing their best stuff for the Apple iOS system and not for Android, and then that hurts Android. So that's the offense by DOJ and the EC, and then that's the defense by Google. Some of the problems that the EC ran into, and the DOJ is now running into, is that Google has already allowed quite a bit of customization. It is not at all fair to say that the Android operating system is just like the iOS system with a little bit of customization. You can actually do a whole lot of customization on Android. The only thing Google is trying to prevent, says Google, is true incompatibility that messes with apps. Another point is we now have a natural experiment. The EC had their case. Google agreed to comply with some of the requirements that the EC has had about reducing its anti-fragmentation agreements. And the EC said, well, that will allow 1,000 flowers to bloom. Let's bring in the incompatible forks. Well, we haven't seen very many. In fact, we've seen almost none of them. And DOJ, unlike the EC, which hadn't had that experience in 2018, DOJ, as it litigates its current case, is going to have to deal with that, what economists call natural experiment. They're going to have to say, well, if it is true that there are tons of incompatible forks just waiting to compete with Google and Google search and all the rest of it, we've had 4 years of it now, 5 years of it now from the EC decision. Why aren't they all over Europe? I actually don't know what DOJ's response to that is. It's going to be an interesting part of that case, but they are going to have to come up with an explanation about if their but-for world is so wonderful, well, where is it right now in Europe? So next, self-preferencing. This is a new question. We're now leaving the apps alone, and we're going to talk about Amazon. This is the argument that's primarily being made against Amazon right now, where a platform sponsor both does platform competition. So Amazon competes with Walmart, for example, to be a marketplace for wholesalers to retail their goods. Where that platform sponsor also has its own goods, which is Walmart's own groceries or Amazon basics. You may have seen they do everything from luggage to socks and underwear. If this platform sponsor is giving additional prominence to its own goods and is doing so in a way that is misleading or that is unfair or that is stealing data from its retailers, is that a problem? So Amazon Prime, Amazon Basics, some of these other things. The big question here is some self-preferencing is expected. Some of it is even competition. How much is too much? That's actually not a real easy question to answer. The UK CMA has been bringing this case against Amazon. It's been going on for a couple of years now. The investigation's been going on for 3 years, and the case has been going on for 1.5 years. It's been so the argument that the UK has made is that Amazon is misusing third-party seller data. It's observing how users are interacting with those third-party sellers. It's harvesting that, and it's turning around to use that data against those sellers to preference Amazon's own retail businesses that are competing. It is putting its own products too prominently, whatever that might mean, in preferred locations in the buy box. You probably have experienced this. So you go to buy a piece of luggage and they say, all right, here are the 5 retailers that we see customers like the most. And oh, by the way, here's Amazon's. And then there's the eligibility criteria for sellers to list. And the argument there is that Amazon is unfairly and possibly even monopolistically reducing the eligibility of certain sellers to get into the buy box or to get on the system at all. One of the things that Amazon is accused of doing, for example, is blocking sellers from being under Amazon Prime or sometimes selling at all if they are offering cheaper goods on other platforms. And Amazon's response to that is, well, I'm trying to make sure that my consumers, the consumers on Amazon, are getting the lowest prices that are available. What the agency is saying is, well, but that prevents competition from the other platforms. Is that okay? Is a most favored nations requirement like that okay? The answer under the law is sometimes, and that's way too thorny for me to go into in the hour we have. But that is one of the issues that is being litigated. A key thing I want to mention here, because this gets into something kind of fascinating, is this a monopoly leveraging case where you use power in one area, Amazon sale power platform, to gain power in another area, such as the retailing the particular product? Or is it something called a product design case? The US government has never won a product design case. And what I mean by that is if the litigation turns out to be a fight about whether a company has designed its product, or here its service, its platform, correctly in a way that consumers like, no court has ever said they want any part of that. So as you can imagine, Amazon says, when they say, is this a product design case? Amazon says, absolutely. I'm using the data to compete, to create something that consumers like. I'm constantly testing to see what the consumers like. Consumers like seeing the competition from Amazon Basics. They like the protection that I'm giving them, et cetera. It's a consumer-facing design. If they don't like it, they would leave. And therefore, I have a defense. You just don't like the way I'm designing my product, but I get to design it. As you can imagine, CMA says, that's not a product design case. I'm not telling you how to design your product. Instead, I am merely telling you, design it however you want, but don't misuse data, don't cheat, steal, lie, whatever it is, to monopoly leverage. It's interesting, whoever wins that definitional matter is going to be, 9 of the 10 steps towards winning the case. In July of this year, Amazon said, look, all right, we'll treat all sellers equally in the buy box. We will reduce the amount that we put in Amazon Basics for example, and the CMA is sort of chewing on that as a partial settlement. But these are some of the questions that are being litigated.
Hey, Hill, there's been a rumor that there was going to be a great cage match in the tech sector between Zuckerberg and Musk. But today's New York Times has an article that says the real cage match is between the FTC and Amazon. Can you just give it its late breaking news? Can you maybe touch briefly on the U.S. case against Amazon and how it may differ from the slide on the U.K. piece?
Sure. So the U.S. case, so just yesterday, and this was after I created these slides and distributed them because the FTC has it in for me. Just yesterday, the FTC actually sued Amazon. They finally birthed their own U.S. case against Amazon. It looks a little different, and it looks a little different because of a Supreme Court case that we're going to get to in a minute called Trinco, that basically says you are not forced to give access to your own platform to other people who want to do only part of what you were doing. The US law does not require that, at least if you're in a regulated industry or something that looks like a regulated industry. So the FTC's arguments are a bit less direct, and the FTC is running a long way away. They're definitely trying not to talk about product design at all. Instead, the FTC is making a huge part of their case is this MFN provision, is this idea that Amazon kicks people out, or at least kicks them out of Amazon Prime shipping, which is a real important part of their relationship with their customers, will kick those people out if they are selling for lower prices on other platforms. The FTC is doing that because, number one, they're just as aware as I am that nobody has ever won a product design case. And secondly, because the FTC does have a history of winning MFN cases. Most of those cases are in healthcare, where they're saying that, for example, big health insurers are hurting small health insurers by not allowing doctors to discount for the small health insurers. There's some economics, some good economic research that's been done over the last 10 years that says in particular situations, MFNs do increase prices, even though you think they might lower prices. They tend to increase prices because if you can't reduce your prices to the small guys as a way of getting just a little bit more commerce on the small guys, then you won't bother to reduce your prices on the big guys platforms because it would be what's called critical loss. You'd lose too much money reducing your prices on Blue Cross, for example, to be worth it to reduce your price and try to gain just a couple more subscribers on a smaller insurer. The argument here would be the same, that although Amazon says the price reduction guarantee is actually lowering prices on Amazon's system, the FTC says, no, you might think that's what happened, but in fact, that keeps prices high on Amazon's system because you're selling so many on Amazon's system that it's not worth it to be forced to reduce prices there just to go pick up a couple more sales on whatever that is, whether it's Etsy or Walmart or something like that. So that's really the difference is a little bit in tone, but basically it's the same case. So going back to the platform virtuous cycle, I mentioned there is also the platform death spiral. It's just basically the virtuous cycle in reverse. This is what everybody is concerned about who runs a platform. And the claim is that this actually can happen. You get payment friction, you get fraud, you get unwanted porn, you get your children's data being shared, and you start to drop off, and there are fewer users. And then there are fewer devices. And then the accessory makers depart, and then the consumers depart, and blah, blah, blah. And you quickly you lose your network specs and things go away. So the question is, does this really happen? Well, it's a great question. And I hear all the time. So for example, people say, all right, so people say MySpace went away and Facebook replaced them overnight. And that indicates that even if you're really big, your monopoly position is not unassailable. But is that really true? I don't think it's true, say some people, because those are just individual companies. And instead, what we're talking about are platforms, and platforms are a lot stickier. Has that really ever happened to a platform? People say, well, it kind of happened to Unix, and they say, all right, Unix is a one-off. Unix didn't really have a platform sponsor. It was kind of abandoned by IBM back in the day. There wasn't a strong central company, so you can't use that example either. So can't use MySpace, can't use Unix. What can you point me to? Well, I love this picture. Do you know, Milam, can you think of anything else that happened? So this is Forbes saying basically Nokia is running this platform of the Symbian operating system, and man, it is unassailable. 1 billion customers. Can anyone catch the cell phone king? And the answer obviously was no. Forbes says, invest in these guys. I put the date up here. Milam, you know anything that happened in the fall of 2007?
Oh man, you're testing my memory here. I'm going to use my Google platform. Give me 1 second.
I'll put it up on the screen.
Okay.
So the iPhone gets released in the 2007. Right in the middle. I mean, this is just a great example of journalists getting way out in front of their skis. They basically say, Forbes says Nokia is here to stay. 100 years from now, we're all going to be on Nokia phones. Well, the iPhone gets released in 2007, Android gets released in 2008, and Nokia's Symbian just absolutely goes to hell. And so what killed it? Fragmentation and incompatibility. There wasn't a central app store. Nokia did a terrible job of that. There wasn't a central payment system. People say, well, the tech wasn't there. Yeah, that's kind of chicken and the egg, though, because people didn't put the tech into it. Maybe the phones would have had to be bigger, but there wasn't really anything preventing you from doing an Android or iPhone technically at that time. Yeah, the touchscreens weren't as good, the batteries weren't as lasting as long, the phone would have been larger, but that really wasn't the problem. The problem was Nokia had a combination of what's called a walled garden and a wild west. There are certain things that they wouldn't open up, so people couldn't develop. And then there was other things that were completely wild west, so there was total incompatibility. And Google famously, when it was trying to put out, it was trying to get its browser, for example, into the mobile environment. It had a closet in Mountain View, where its headquarters, that had something like 400 different Nokia compatible Symbian phones in it, all of which had different problems with them. So they had to write their software slightly differently from each one, and it was tearing its hair out. And that is why Google bought the nascent Android operating system back in 2006, I think it was, and eventually turned that into a company and released it in 2008. Google didn't want to be a phone manufacturer, but it found itself completely drowning in incompatible devices. There also was no ongoing revenue stream that caused Nokia to keep its skin in the game, and because it wasn't charging for an app store, for example. So there was no reason for it to continue to care about the device once consumers bought it. Nokia was only making, or almost all of its money, with new devices. So Nokia had, in a sense, an incentive for people to say, this device stinks, I got to throw it away and get a new one. So that is a big thing over here. No ongoing revenue stream post the device sale. That was a big flaw in how they set it up. And guess what? Steve Jobs and Google looked at that, and they created systems that solved each one of these problems. They solved it in very different ways, but both of them do have an ongoing revenue stream. So that's a key. And of course, what happens if you have an ongoing revenue stream and you were sued, and you were successful? Well, somebody's going to sue you for antitrust, and hopefully you hire me. But before you get to that, let's talk about the case. So these are the App Store cases. There are separate cases, a bunch of different cases. They're both class actions, separately filed in 2020 against Apple and against Google. And Epic Games was the lead plaintiff, and I believe the first plaintiff in this series. There have been a lot of different Me Too plaintiffs after that, but Epic Games was the publisher of Fortnite, and it was offended by the fact that it was an extremely popular game. And then Apple and Google's app stores both had a provision in there that they said they got 30% of the in-app revenue for any app that was used. So when Fortnite was making a whole lot of money for selling so-called loot boxes and upgrades within the game, they would have to send 30% of that money to Apple and to Google. And their initial reaction was, well, we're so big, we don't need them anymore. We'll have people download those apps directly outside the App Store. Apple will not let you do that. You can only download apps through the App Store. Google will let you do that, but it will put up a warning that says, look out, when you are downloading directly from the internet, it hasn't gone through our app store, and therefore we don't know whether there's viruses and stuff in it. And also, you're going to have your own payment system. So you're going to have to figure out your own wallet in that situation, because you won't be using the Google App Store digital wallet. One of the things that both the Apple App Store and the Google Play Store have is they have an integrated wallet digital payment system. And that's one of the ways that those companies know exactly what kind of loot boxes or whatever you are paying to your app. That's because it goes through that wallet. So they effectively monitor it because they're running the payment system. The alleged, Epic fails in its effort to create its own app store or to get people to download it directly, and then it turns around and it sues for antitrust, and it says, monopoly maintenance, you are competing with me, or you are competing with my my argument that I should have my own payment system. And that is a different market. That is not the App Store market. And therefore, you are maintaining a monopoly in those payment systems or in apps by virtue of leveraging your dominance in the App Store or in the operating system. That's the argument that Epic Games makes, and those litigations continue to be fought today through all sorts of motions and dismissed that I don't have time to talk about. But the interesting thing, I think, one of the most interesting things, and a difficult thing that really bothers the plaintiffs there, is Epic is basically saying, well, iOS is closed, Android is open. Can it really be the case that neither of those designs is lawful? Epic says, no, they're lawful. It's just the particular leveraging that they're doing is unlawful. But again, if this gets defined as a product design case, Epic and those other plaintiffs are going to lose. Therefore, they are trying to say, no, 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 it's not product design, it's monopoly leveraging. We got another poll there, so everybody please look at that. So when I was talking about this in a similar CLE that was just about the Android cases and the App Store cases a while ago, I got a great question from the audience, and they said, you're completely missing the point, Hill. These are utility cases, and you haven't mentioned big platforms as public utilities at all. That is what these guys are saying if you hear them speak at tech conferences, and that's the legal theory. And I wasn't aware of that being said at tech conferences. And I know that's not the legal theory. And so I went and poked around and I thought, is that really what they're saying? And that is, a lot of times, that's what a lot of people say. Now, I'm not just picking on Epic. That is what a lot of people say when they go after platforms. These should be, or they are, public utilities, and we need to regulate them like a public utility. So why isn't that showing up in any of these litigations? You'll see that I haven't mentioned it. Well, there is a very clear answer to that, and it is this Supreme Court case, Verizon Communications versus Trinco. This is one of, to legal scholars, to law professors, this is one of Antonin Scalia's, the late Justice Scalia's most famous cases. It's brilliantly written. It's worth reading. And here are some quotes from it. I won't go through the whole thing, but basically what it says is the antitrust laws are set up to prevent people from acquiring monopoly power through various different actions, such as acquisitions, such as certain fraud, other things like that. But once somebody has built something from scratch, we don't treat it as a public utility under the antitrust laws. If you're going to regulate as a public utility, there are other things that exist to do that. Congress would have to do that. Congress would, for example, have to say interstate pipelines are going to be regulated as public utilities, interstate telephone lines or electrical transmission, and Congress has done that. But in the absence of Congress doing that to an app store, he wasn't writing about an app store, he was writing about a fiber optics communication system. In the absence of Congress doing that, we in the antitrust are not going to do it. And if Congress does do it, then we're going to leave it towards that uh, regulatory regime. We're not going to make antitrust do it. So there is no essential facilities doctrine or public utility doctrine in antitrust. And it is very difficult to have a so-called refusal to deal case by itself. So that is the reason that there is a disconnect between what is often said in the media about why we are bringing some of these cases, and then what you actually see if you look at the complaints, look for the motions for summary judgment, look at the legal pleadings, you don't see public utility and refusal to deal in essential facilities being argued there. So that's a big disconnect that I think was really important. And I forget who asked me that. I actually never learned her name, but she asked a great question, and I thank her so much for doing that.
Hey, Hill, picking up the theme of disconnects between what you read in the media and what comes out in these cases, if you look at anything about the litigation you're talking about with the App Store and the Google Store, you see phrases like excessive pricing, excessive commissions. I noticed that you didn't use those terms as you were describing the cases. Can you maybe just spend a second talking about the legal significance of those terms and why they get kicked around?
Yeah, it's exactly the same problem. The United States does not have excessive pricing laws under the United States under the federal antitrust laws. Price gouging, excessive pricing, and things of that nature, they do exist under state law, almost exclusively in one area, which is retail gasoline in the context of hurricanes. And otherwise, it is a foreign concept in the United States, and it's for exactly the same reason that this Trinco case is up, which is why I just backed up into the slide. There are previous cases, I think Trinco cites a couple of them, that have that talk about why we don't do excessive pricing in the United States. And it's the same sort of logic that a monopolist having gained its position lawfully should not be criticized for its pricing. We believe that the judgment has been made by the grand thinkers of antitrust and economics that it's more efficient to let the monopolist price at the level that it wants to, because that will ultimately entice other people to come in underneath that, underprice them, and compete with monopolists. At least that is the theory. In the United States, we don't have excessive pricing law. We do have it in Europe to some degree, and we especially have it in Asia, but it is not a United States concept. So that's why, again, you hear that a lot in the journalism, but you don't see it in the cases. So coming towards more of the end here, we've got a couple of other cases. Monopoly maintenance via startup acquisitions. The concept here is, do the big incumbents really figure out who is going to be their competitor, and then strangle those guys in the crib, or so-called buy and bury? I guess in theory that's possible, but for those of you, especially anybody who's in the Austin incubator community, this kind of terrifies the little guys, not because they aren't worried about being buried, and it's not like the little guys necessarily love the big guys. The problem is, for the little guys, a whole lot of the way they get funding is the possibility of exiting by selling to the bigs. So anything that increases the friction or reduces the chances of a sale to the bigs is something that the little guys, ironically, really don't like. And a lot of times the little guys don't have any money, or they're not they're not profitable at the time they sell out. So then there's a question of, under the United States antitrust law, do you have a failing firm defense? You're allowed to sell, even if it would be otherwise anti-competitive, if your firm doesn't make enough money and would go out of business if you don't sell. Those are some of the broad issues. There was a great quote by Judge Frank Easterbrook, who's one of the leading thinkers of antitrust. He's a judge on the Seventh Circuit. And it really applies to this situation. We want to stop monopolists from doing bad things. We do want monopolists to continue to compete because that's highly beneficial. How do you tell the difference? And he wrote a whole article that said, damn it, it's really hard to do. These things look a whole lot alike. And that is, in a nutshell, what's going on with a couple of these cases going on right now. So quickly, Facebook bought Instagram and WhatsApp in 2012 and 2014. The FTC, 8 and 6 years later, sued Facebook, now called Meta, to unwind both of those deals. It had actually approved one of those deals. The other one was too small to need HSR approval. Initially, the judge said, what are you talking about? You approved these things. This is really complicated. Forget it. I'm dismissing this case. The FTC went ahead and repleaded in a much better way, and now survived a motion to dismiss, and that case is set for trial next year. The argument here is that Facebook, from the very beginning, had figured out that it is better to buy nascent competitors than to compete with them, and therefore it bought in order to prevent competition from breaking out by these smaller companies, because of the possibility that those companies were going to become the new Facebook. That is the legal theory. Such a consummated merger case, meaning the merger already happened and the agencies had let it go, that's really, really hard to win, as you can imagine. The consummated merger cases are pretty common where the agency did not review the deal. But in situations where the agency did review the deal or had the opportunity to, was aware of it and didn't do anything, those are really, really rare. So the FTC is going to have difficulty overcoming hindsight bias there, and particularly the problem of neither Instagram or WhatsApp had a path to profitability at the time. So you would have to not only prove, if you're at the FTC, not only prove that they had a plan to compete with Facebook, but that they plausibly would have by this time still been in existence and been profitable, or at least breaking even to stay around. That's a lot of different threads that the FTC is having to pull together, and that is why this case is sort of limping along. Another version of this is monopoly maintenance via vertical integration. When you vertically integrate, different parts of a production chain or a service chain are put together. That's generally considered to be pro-competitive. There are some possible harms associated with it. One is foreclosure. Integrating a supplier blocks other people who need that product, or just raising rivals' costs. If you haven't blocked them, you've made it more expensive for somebody who needs one of those parts. Those are some of the theories. If you grow by yourself, it's not vulnerable, because that's the Trinco case that I just mentioned. But it is certainly true that if the integration was achieved by buying the different parts, then it can be vulnerable to challenge. Again, though, if you let these deals go by, it's awfully difficult to challenge them. And that's what's going on in the Google advertising case. Google has what's called an ad tech stack, which means a whole stack, if you think about it vertically, of different software that an advertising request goes through every time that you do a search on Google, and then you eventually have a product recommended to you. You've got somebody originates the ad, somebody pays for the ad. You've got to figure out how to match that ad, do an auction for who gets that ad, where does it go on the Google search, and so forth. Each one of these, or a lot of different ones, are done through different pieces of software Some of those pieces of software were purchased rather than developed in-house, although all of them, after they were purchased, were greatly changed and redeveloped by Google. Two of those pieces, actually multiple pieces, were cleared by the agencies. DoubleClick and AdMill were both cleared by the agencies many years ago. But now DOJ has sued in the beginning of this year, saying that Google is monopolizing the ad tech by, first of all, having put all these things together, and secondly, making them work in a way where they work better with each other than they work with third-party competitors, because there are third-party competitors of little pieces of this stack. And DOJ is saying that Google is in some fashion putting a thumb on the scales and forcing those not to work well with each other. As you watch this, again, is this a product design case, in which case DOJ is going to lose, or is it a monopoly leveraging case? And the big question is, can you understand it? As you may know, one of the rules of litigation is simplify, simplify, simplify. This, however, is what the what DOJ has put in its complaint as explaining how this all works. Not very simple. But the other rule is simplify as much as you can, but no further. And it may be that this is just what DOJ's got to do. If this is as simple as they can figure out how to explain the ad tech stack, then I guess that's what they're up against. Real quickly, to cover a couple of other things, you probably have seen no-poach agreements and non-competes. A no-poach agreement says is with another company. You're not going to hire each other's employees. Non-compete is with the employee himself, saying, don't compete with me if you leave. DOJ brought a bunch of high-tech hiring cases in 2010. They were called the high-tech hiring cases. Those are the defendants. And they alleged that they had all gotten together and said to each other, we will not hire each other's employees. DOJ settled those cases under civil law, but they said that any future cases brought would be under criminal law. DOJ backed that up with a whole bunch of cases since 2022. It has lost 4 of them at trial. That gets a lot of press, but be aware that it has settled a bunch of others. So DOJ has not entirely lost these. It has lost them when it's gone to trial, but perhaps that's just because people take the hardest ones to trial. It has settled a whole bunch of others. Definitely do not do no-poach agreements. And if your reaction to that probably will be, well, a naked no-poach agreement is one thing, but what if it is in a joint venture context or a situation where we have a legitimate agreement with each other, not and we're sharing each other's employees and most important information? Can we have a no hire, no solicit there? The answer is yes, maybe, sometimes. Call your antitrust lawyer. But a naked no-poach agreement where you don't have an agreement or JV with somebody else and you just say, don't hire my employees, that's definitely going to get you prosecuted and possibly even criminally. So be very careful about that. On the non-compete, the FTC has proposed a formal non-compete rule. It's actually put out a notice of proposed rulemaking, possibly to be enacted in 2024. Here's what it says, and it basically says in almost every situation you can imagine, you cannot have a non-compete clause in your employment agreements. This is going to be challenged under something called the major questions doctrine, which is a way of saying that the FTC, or any agency, can't make a rule where the question is so important that only Congress should be dealing with it, and Congress hasn't delegated that through the FTC statute, for example. I think that the FTC is going to lose under the major questions doctrine on the non-compete rule and have to go back to square one. But right now, the rule is not final, and therefore lawsuits have not started. People say, when is the non-compete rule going to affect? I don't know, because I'm absolutely certain that it's going to be sued the minute it does go into effect. Look for that to happen in 2024. And then finally, interlocking directorates, and this is my last topic. I think you probably have all heard about Clayton Act Section 8. What that says is you cannot have board members on two competing corporations at the same time because of the possibility that they would share pricing strategies, competitive strategies, what have you. This is a particularly important issue for startups, for startup incubators, for tech companies. If you look at Intel, for example, Intel goes out and tries to create any kind of demand. It funds games, for example, because games use really powerful processors and graphic chips. Intel wants to create the demand for those processors and graphics chips, and therefore it will fund you if you are creating a really intensive game, but then it wants a board seat. Question is, at what point is Intel starting to compete with companies like that? Well, usually the answer is you're not competing, because competitive sales has that definition you see. But when you are competing, you have to worry about this. The message, not to go into too deep here, but the message that I'd like to leave you with is the FTC and DOJ are suddenly very serious about going after interlocking directorates. And in particular, if you happen to have M&A in front of them that gets filed under the HSR Act, they will go through your boards with fine-tooth comb trying to find these problems. So if you're filing a HSR, one of the pieces of hygiene you should do is to make sure that you do not have interlocks. There are de minimis exceptions. This is often how we solve these problems or determine that there are no problems. If you have relatively small competitive sales, that is an exception. But it's very frequently the case that you need to call your lawyer and figure out whether that applies. And finally, the FTC, you may be aware that the Clayton Act only applies to corporations. The FTC has an answer to that. They say that the FTC Act's General Section 5 allows them to attack interlocks even if they are not corporations under what's called their gap filling authority. Let me end it there, Milam, and see if we have any questions before we close.
Great. Hill, if you'll do one more slide for me. I think we've covered up all the questions that were presented, but to the extent that folks have questions after the presentation, feel free to reach out to Hill or to me. As I mentioned at the beginning, the program and the slides will be available in the coming days. We hope to see you in December for our next series of the webinar. This is going to cover standard technology agreements. We'll do some updates on what we're seeing from a commercial perspective. And then we'll be announcing dates and titles for our 2024 program soon. If you have ideas for topics, please, we'd love to hear them and welcome your input. Thank you again for joining us, Hill. Thanks for a great presentation, and we hope you enjoy the rest of your day. See you in December. Thank you.